Management and employers will, I think, have a friend in Judge Kavanaugh on the bench. It's reflected in several of his opinions while he was on the Court of Appeals. You can see that in cases like Adeyemi, where he said that courts shouldn't be super personnel departments. You see it in that same case where he says they shouldn't micromanage what employers do. You see it in many other cases where he says businesses need to do what businesses do, and we need to just make sure they stay within the law. Judge Kavanaugh would be a friend to employers, but he'd also be a friend to employees based on his past decisions. He went out of his way in several cases to make sure that the court was there to stamp out discrimination. For instance, in the Ayesi Etu case, he said one single use of the N-word could in and of itself be a hostile environment, and really drove that home in a concurring opinion. Similarly, in the Ortiz-Diaz case, he had some concerns that the court was not considering lateral transfers to be an adverse employment decision, and he wrote an initial concurrence that actually got the court to reverse itself and then adopt his position. So he was certainly a friend to employees in those cases. Even in Brady versus Sergeant at Arms, where a racial discrimination case was dismissed, he went out of his way, in his opinion, to make sure that people understood that that plaintiff was an alleged harasser who had been terminated for sexual harassment. And he said, look, as long as an employer honestly and reasonably believes that this person was a harasser, that's a legitimate independent basis for termination. So he actually gave a tool to employers to help employees in that case. There'll be many important issues addressed during Judge Kavanaugh's confirmation hearings, and I'm not sure whether labor and employment ones will be part of it, but if they were, I think there's really three cases that we'll be focused on. The first two, Miller versus Clinton and NLRB versus CNN, Judge Kavanaugh in the dissent disagreed with Merrick Garland, who wrote the majority opinions. And the reason that's interesting is because Merrick Garland himself had been nominated for the court and never got a hearing. So senators on both sides may wish to highlight the differences in analysis in those cases. The third case would be the agri-processor case, in which Judge Kavanaugh dissented from a union election decision case in which he said that undocumented aliens should not be part of a collective bargaining unit, shouldn't have been part of the negotiations or the election. And I think it just brings together a lot of hot button issues that senators may wish to focus on. You have union rights, you have collective bargaining, and you have the immigration overlay. So I think it could be a case that gets some attention during the confirmation hearings.